Hello and welcome. This is Habeas Humor. My name is Sharon. I am a lawyer and I am going to talk about Derek Chauvin, who was convicted of murdering George Floyd and whose sentencing hearing is coming up this Friday, June 25th. My goal is to answer all of the questions that you would ask a lawyer about this case. And please, if you have specific questions, put them in the comments. I read all the comments and I will do my best to answer everything. We are going to get into the details of the case in terms of where things stand now and what is likely to happen going forward. The thing is, though, there is a lot to cover. There are the 3 different crimes at issue, the separate federal charges, the 3 co-defendants, the post-trial motions, sentencing, appeals, and a partridge in a pear tree. That's a lot of legal news. So we are going to cover it in chunks.
Giving our views on the legal news.
Chauvin Chunks. Rather than several full Habeas Humor episodes with all the core segments, this is going to therefore be an a la carte Chauvin miniseries. The patron shoutouts and audience participation and all of that will return when the show goes back to its normal format. Right now, let me just say thank you from the bottom of my heart to every person who has contributed to Habeas Humor through Patreon or one-time donations. Patreon is going to charge just once for all the Chauvin stuff, regardless of how many episodes it ends up being. If you would like to contribute to the show, use the links in the description or go to habeashumor.com, and please know that I am not trying to profit off of George Floyd's death. I cannot see how there is any chance of that happening. I started Habeas Humor in 2017, and the show has been operating in the red to this day. So even if we gain several patrons from doing these Chauvin chunks, there's no shot that this income will exceed what it costs to make the miniseries. If that should miraculously happen somehow, then I will donate the excess. We will do a poll or something to choose a worthy civil rights charity. Now that I have done that financial disclosure, let's get to the content you tuned in for. For the benefit of anyone watching or listening from far in the future who does not know the story of this case, I will quickly explain. Derek Chauvin was a Minneapolis police officer who killed a man named George Floyd during an incident of extreme police brutality. Derek Chauvin and 3 other police officers were taking George Floyd into custody on suspicion of trying to use a counterfeit $20 bill to buy cigarettes at a store. George Floyd resisted arrest, and from there things got very violent. Floyd was eventually pushed face down onto the ground, and while he was face down and handcuffed, Derek Chauvin knelt on George Floyd's neck for several minutes, causing Floyd to die from asphyxiation. 3 other police officers all participated to some degree, and those officers are now co-defendants in the criminal case. There's a video of the killing, which I am not going to show, but thank goodness it exists. Or therefore there probably would have never been any justice for this. You may be noticing that there are gory details to the crime that I have not mentioned. We will get into more detail later because it is relevant to the sentencing, but for the sake of time and my sanity, I am not going to go into every single gruesome detail. The video is available if you have not seen it, and it speaks for itself. That said, please take all the appropriate content warnings from this. Violence, racism, police brutality, murder, and some drug use. I do need to stress that this crime is of great social importance because not only does it involve police brutality, it also involves racism. George Floyd was a black man, and there is little doubt that he would have been treated differently if he was white. You see, the USA is and has always been white supremacist, and there is a long pattern continuing to this day of black people being treated worse than white people. Some of you watching this might be shaking your heads because you think I'm lying, so ask your Black friends, which I'm sure you have a lot of. Ask any Black person who is comfortable being honest with you. Ask them how many times they have been pulled over while driving, even though they were following all the traffic laws. Ask them how many times they have gone to a restaurant and been treated like they were not wanted there. Ask them if they have ever been turned down for an apartment for no apparent reason. Find out how their job interviews tend to go. Find out what the experiences are for as many people of color as you can, and compare that with your own experience. If you are white, then I bet you a shiny nickel you will discover that you tend to have an easier go of it in society than your Black friends. Is that anecdotal evidence? Yes. But personal stories can be eye-opening. Oh shit, did I just break the law? Did I just talk about critical race theory? I might have just broken the law, depending on what state you're watching from. Sorry. Here, I will teach the controversy. Here are some alternative facts that I have heard from right-wingers and systemic racism deniers. George Floyd died due to nothing other than his own fault, and most of the world freaked out about this for no reason. There you go, don't report me. Look, if you are a believer in those alternative facts, then I don't know what to tell you. There was a trial in which a jury heard the evidence, and at the end of it, they found Derek Chauvin guilty of murder in the second degree, also guilty of murder in the third degree, and manslaughter in the second degree. The difference between those three crimes is something we will discuss in detail in the next episode of Chauvin Chunks. For now, just keep in mind that Chauvin was found guilty at trial, and the most severe charge was murder in the second degree. Also, to reiterate, there are 3 co-defendants, Alexandra Kung, Thomas Lane, and Tu Tao. They were the other 3 police officers who participated in arresting George Floyd, and all 3 of them have been indicted criminally by the state of Minnesota. They have not gone to trial yet. The court had previously decided that all 4 police officers should go on trial together, but the court eventually had to go back on that. The court decided that there needed to be separate trials due to pandemic safety. Essentially, there was no courtroom large enough for all 4 defendants, plus their lawyers, their families, their witnesses, the press, and so forth. We will probably discuss that more in a future episode, but I now want to get right into the sentencing process and my predictions for the hearing on Friday, June 25th. When it comes to criminal sentencing, the sentence that a person gets for committing a crime anywhere in the United States is pretty much always decided by a judge. A jury might decide guilt or innocence, but once there has been a guilty verdict or a guilty plea, a judge does the sentencing. The only common exception is that in some states, such as Delaware and California, if a death sentence is going to be handed down, it has to be by a jury. The jury first decides guilt, and then if they convict, they do basically another sentencing phase of the trial to decide whether or not to impose the death penalty. So that is an exception, but the general rule is that judges impose sentences for crimes. And this is kind of a good thing because judges, at least in theory, should be well qualified to make prudent sentencing decisions using their knowledge of the law and the facts of the case. Unfortunately, judges sometimes make crap decisions. The United States Sentencing Commission, which is part of our federal judicial branch in the United States, has done a study about this, and their findings say that our judicial system is discriminatory in its sentencing practices, particularly towards Black male defendants. The link to that source is in the show notes. Black men tend to get prison sentences that are too long. On the other side of the scale, you have white fuckboys like convicted rapist Brock Turner, aka the Stanford rapist, who was sentenced by Judge Aaron Persky to a shockingly brief 6 months in jail. Brock Turner then got released early after serving just 3 months. Fortunately, in California, where this case happened, at least fortunately in this case, judges have to be confirmed by the voters every 6 years. There's definitely a lot to be argued about whether it's a good idea for judges to essentially have to be politicians. But at least they're accountable to the people. So the next time that Judge Persky's job was up for a vote, the public got rid of him. He then obtained a job as a high school tennis coach in Fremont, California for a JV girls team. And he had that job for all of one day. Then the parents in the school district realized who he was and they had him fired again. You could argue that it was a little unfair, but maybe not. Maybe parents had good reason to think that Coach Persky was not going to be a stellar guardian of their daughter's safety in that environment, high school sports. But anyway, yeah, racism in sentencing, we have that. And it is one of the flaws of leaving sentencing up to the judgment of just one person. Not that it can't happen with more people, but I feel like maybe it should be up to like a committee of judges or something, similar to the way parole works in a lot of states. Perhaps there would be more consistency and equality that way. Just an idea. Well, in any case, after a person is convicted of a crime, the judge decides the sentence. The judge has to follow what the law says about the penalty for the particular crime. Sometimes the law gives the judge a lot of room for discretion, and sometimes it does not. It depends on what the crime is and what state the crime occurred in. The killing of George Floyd occurred in Minnesota. Now, you may be surprised to learn this about Minnesota, but it is on the liberal side of the scale as far as penalties for murder. It is theoretically possible to be convicted of murder in Minnesota and get no time. And if you have followed the news, then you know Derek Chauvin's attorneys are seeking a mere probation sentence for him. Don't worry, it will not happen. More on that later. What about the worst case scenario for Chauvin? Does Minnesota have the death penalty? No. Minnesota abolished the death penalty all the way back in 1911. Maybe that's why the cops carry out their executions. Oh shit, did I just say that? I'm sorry. Apologies to all the Minnesota cops who did not kill George Floyd. Send your complaints to @Habeas Humor on Twitter. So what, you ask, is the penalty for murder in Minnesota? Great question. I will answer it, but first, as a comparison, I want to show you what would have been the penalty if this same crime had occurred somewhere else, let's say my home state of California. Anyone know the penalty for murder under California law? Raise your hands. According to California Penal Code Section 190, every person guilty of murder in the second degree shall be punished by imprisonment in the state prison for a term of 15 years to life, unless there are aggravating circumstances that will make the sentence even longer. You may have noticed that I skipped over the part about first-degree murder, and that is because Derek Chauvin was not convicted of first-degree murder. Just know that in California, first-degree murder carries a minimum penalty of 25 years to life and a maximum penalty of death. Yep, California has not abolished the death penalty. It was effectively abolished for a while by the California Supreme Court, but in the 1980s, those lib judges were voted out of their jobs, just like Judge Persky. It was a whole thing. One of the judges that lost their seat was the late, great Rose Bird, who was the first California woman Supreme Court justice, and also the late, great Cruz Reynoso, who was a wonderful person. I knew him because he taught at my law school, and he recently passed away. He was really, really a great person. He did a lot for the poor, the minorities, and just was really, really nice. But anyways, the California legislature has never abolished the death penalty. You may be wondering, what is the legal difference between first-degree murder and second-degree murder? So I will give you a quick rundown of that. I'm just going to say that with regard to all of the black letter law that is relevant to this case, I am trying to strike a balance. I could be very precise, but at the cost of boring you with endless reading of statutes, or I could just quickly summarize, but at the cost of leaving relevant things out. So I'm trying to keep from going too far in either direction. When we get to the specific crimes that Derek Chauvin was found guilty of in Minnesota, next episode, I will read you the exact legal definitions. But for now, just know that in general, second-degree murder is basically the default. There are facts that can make the crime especially bad, and then first-degree murder could be charged. Or if there are facts that make the crime less heinous, then manslaughter or third-degree murder could be charged. In California, the circumstances that would constitute first-degree murder include things like torture, bombing, or killing someone during the commission of another crime like a robbery, and the big one, premeditation. Premeditation, at least as defined in California, more or less means setting out to kill someone and then doing it. It requires a conscious intent to kill. However, that only has to take a moment. This means that in California, at least, virtually every intentional killing is going to meet the elements of first-degree murder. What about the things that qualify for a lesser charge of manslaughter? Mostly heat-of-the-moment killings. The textbook example is a case where someone discovers their spouse committing adultery in front of them, and they lose control and they kill their cheating spouse. Crimes of passion tend to be charged as manslaughter. On the other hand, a straight second-degree murder will generally be an unintentional killing that was done without provocation, but with a depraved indifference to putting human life at risk. For example, firing a gun in a random direction, or sitting on someone's neck because they are resisting arrest. For now, we are going to focus on second-degree murder because that is the most severe charge that Derek Chauvin was convicted of, and that is the charge his sentence will be based on. I will do another episode all about the jury verdict and whether any of the charges might be overturned on appeal. In that chunk, we will get down into the specific definitions and elements of each of the three crimes. There has been a great deal of concern on the part of the public due to the way sentencing works in Minnesota. Minnesota is very different from the example state I gave, California. The law in Minnesota gives a wide range of possibilities for how a murderer can be sentenced. Had the murder of George Floyd happened in California, Derek Chauvin would be sentenced to 15 years to life, case closed, except if he wins an appeal. Again, appeals are another show, and we will talk about that in another episode. You know as I do, however, that this murder we are discussing did not occur in the state of California, but rather in Minnesota. Because of that, people have been in kind of a frenzy over what Derek Chauvin's sentence might turn out to be. Minnesota law gives judges a huge amount of discretion in sentencing. Minnesota Statute 609.19 says a person guilty of second-degree murder may be sentenced to imprisonment for not more than 40 years. Take note of the word may. Totally different wording from the law in California, which says a person guilty of second-degree murder shall be sentenced to 15 years to life. Shall means there is no choice, but in Minnesota, a person guilty of second-degree murder may be sentenced to imprisonment of not more than 40 years. That means by implication that a person guilty of second-degree murder in Minnesota may not be sentenced to prison. It is up to the judge, and any sentence not longer than 40 years is permissible. Get ready for a twist, though. In Minnesota, prison sentences are 1, determinate, and 2, bifurcated between incarceration and supervised release. I will explain. A determinate sentence means that it is X number of years and that's it. An indeterminate sentence is like they do in California when they say 15 years to life. The sentence may end up being anywhere from 15 years to life, depending on if and when the person gets paroled. Indeterminate. There is no such thing in Minnesota as X years to life. They do determinate sentencing. It's X years, period. So if you get 40 years, it's 40 years, not 40 years to life. If you get 10 years, it's 10 years, not 10 years to life. However, prison sentences in Minnesota are bifurcated, meaning split, cleft in twain. Under Chapter 244 of the Minnesota statutes, the last third of every sentence is supervised release, which is basically parole. Minnesota does not have a parole board. What happens is that once a prisoner gets through 2/3 of their sentence, they get out for supervised release unless the Commissioner of Corrections refuses to let them out due to disciplinary reasons. There is no time off for good behavior in Minnesota, but there is extra time for bad behavior. So if someone breaks the rules in prison, tries to escape, attacks prison guards, things like that, their supervised release can be postponed. Otherwise, the term of imprisonment is 2/3 of the total sentence, followed by supervised release for the last third. Remember that the longest allowable sentence for second-degree murder in Minnesota is 40 years. So for Derek Chauvin, the maximum total amount of time he can be in prison is 2/3 of 40 years, which works out to about 26 and a half years. And he gets credit for whatever time he has already spent in jail, like during the trial. That counts towards the term of imprisonment. Now, if you were hoping for Derek Chauvin to be put in prison for a really long time, then you're probably disappointed. And therefore, I am extra sorry that I have to be the bearer of more bad news. The full 40-year maximum is not even on the table for Derek Chauvin, or at least the prosecution is not going for 40 years. Yes, in theory, the judge could give a 40-year sentence without the prosecution asking for it, but that is pretty much unheard of. The prosecution has asked the court to give Derek Chauvin a 30-year sentence, which under the 2/3 formula means Chauvin would really just do 20 years in prison and then go on supervised release for 10 years. Why is the state asking for less than the maximum, you might wonder? The answer is found in the Minnesota sentencing guidelines. To be clear, the sentencing guidelines are just that, guidelines. They do not override the law that says the judge can impose a sentence of 0 to 40 years for second-degree murder. However, the state of Minnesota published these recommendations to help guide judges and give them standards for what a proper sentence should be. So if a judge just throws the guidelines out the window, it will be a pretty good, solid ground, I think, for a cruel and unusual punishment constitutional challenge, because the standards were not followed. It was arbitrary, and, if it's unusually long, there you go. In the Minnesota sentencing guidelines, there is a handy chart that contains recommendations for the sentence a person should receive based on the severity of the crime and the person's criminal history. There are ranges, as you see here, and it's in months. A person who is convicted of murder in the second degree without intent to kill and who has no criminal history should get between 128 and 180 months. That is a minimum of 10 and 2/3 years and a maximum of 15 years. Nowhere near the maximum of 40 years. According to the chart, to get 40 years for this crime, the offender should have a really, really severe criminal history. But the chart is not the be-all and end-all of the standards. The guidelines also say that departure from the recommended range is appropriate in some cases. If there are aggravating factors that make the crime especially heinous, then it is totally in accordance with the guidelines for the judge to give a longer sentence than what the chart says, up to the maximum allowed by law, in this case 40 years. If there are mitigating factors that make the crime especially non-heinous, then it is totally in accordance with the guidelines for the judge to give a shorter sentence. What is meant by aggravating and mitigating factors, you might be wondering. These are listed starting at page 52 of the guidelines. First, they give examples of the mitigating factors, those that might mean the sentence should be shorter than what the chart says. Mitigating factors include, but are not limited to, the victim being an aggressor, meaning they provoked their own killing somehow, or the offender being only a minor player in the crime. These are examples of mitigating factors. On the other hand, aggravating factors that might warrant a longer sentence include, but are not limited to, the crime being particularly cruel, the crime being a sex offense, or the crime being committed in the presence of a child. There are more factors on the list, and if you want to read them all, then please see the show notes where all of the sources are linked. The prosecution in the Chauvin case has submitted a written sentencing brief to the court in which they argue that because of aggravating factors, the sentence should be higher than what the chart says. Again, according to the chart, Chauvin should get a total sentence of 10 to 15 years if the crime is quote-unquote standard. However, in the state's memorandum of law on sentencing, which they filed on June 2nd, the prosecution requests a sentence of 30 years. They spend 21 pages explaining why. Feel free to read the whole thing. I will give you just the capsule version. The prosecution lists 4 aggravated sentencing factors. Number 1, Chauvin abused a position of trust and authority. That's pretty self-explanatory. He was a police officer who acted improperly. Under the guidelines, that can elevate a crime to a longer sentence. Number 2, Chauvin acted with particular cruelty. Specifically, the prosecution points out that George Floyd's death was caused by prolonged asphyxiation as he was begging for his life and was terrified by the knowledge that he was likely to die. Pardon me, that is very disturbing every time I read it. The third aggravating factor is that there were children present during the crime. According to the evidence, there were 4 child witnesses, the youngest 9 years old. All of them saw George Floyd being asphyxiated as he begged for his life. Finally, the fourth aggravating factor is that Derek Chauvin acted in a group with 3 other individuals who all participated in the crime. Remember, there were 3 other police officers who have been charged with this murder as well and who have not yet gone on trial. That will happen in the near future unless a plea bargain is reached and they plead guilty. We will definitely do another episode regarding those 3 co-defendants. At the end of their sentencing brief, the prosecution quotes Minnesota precedent that says, if there are aggravating factors in a crime, the appropriate sentence should be increased from what the chart says by up to double. Once again, the maximum on the chart for this crime with no criminal history is 15 years. Double that is 30 years, so 30 years is the sentence the prosecution is asking for. The defense filed a sentencing brief as well, and they say 30 years is fair. Not. No, Derek Chauvin is asking for a lot less than that. Let's look at the defendant's brief. This was also filed on June 2nd. Right up top, the defense says, we are asking the court for a downward departure from the sentencing guidelines. They want a shorter sentence for Chauvin than what the chart says. The defense argues that because of mitigating factors, the court should sentence Chauvin to just the time he has already served in jail plus probation. If you think that is outrageous, I agree with you, but let's read the brief and hear them out. It starts, as most legal briefs do, by giving a summary of the facts of the case, and here is how the defense phrases things. Quote, on May 25th, 2020, defendant Derek Michael Chauvin, then a Minneapolis police officer, and his partner responded to a call for backup from fellow officers who were attempting to arrest George Floyd outside the Cup Foods store on 38th Street and Chicago Avenue in Minneapolis. He arrived to find the officers on the scene struggling to place Mr. Floyd in the back of their squad. I don't know if it's supposed to say squad car or if squad is just the term of art. Mr. Chauvin assisted the other officers in restraining Mr. Floyd as they waited for an ambulance to arrive. During the restraint, Mr. Floyd ceased breathing. Paramedics attempted resuscitation after they placed Mr. Floyd into the ambulance. Mr. Floyd was later pronounced dead at Hennepin County Medical Center. End quote. So you might say some stuff was downplayed there. Everything that Derek Chauvin and the other officers did to George Floyd was described with just one word: restraining. Restraining can mean a lot of things, and it can encompass a wide range of brutality. The defense does not go into any detail about it. They try to gloss over it by simply saying the police restrained George Floyd. And then, in what seems like an effort to make the events seem as unrelated as possible, the defense says during the restraint, Mr. Floyd ceased breathing. No reason for that stated. So, not necessarily because of anything anyone else did. His body just decided to stop breathing. So, that being the case, with the facts framed the way the defense has done, this was just one of those things. At worst, an accident. And I say at worst because, as you probably know, one of the defenses that Chauvin raised during the trial was that he didn't even cause the death of George Floyd. It was a mere coincidence, like maybe because Floyd had taken some bad drugs or something. The jury didn't buy it. They found that Chauvin did cause Floyd's death. So at this point, the sentencing stage, the defense sort of has to acknowledge that Chauvin was at fault, but they are not going to just come out and say it, and they are going to word everything in a way that minimizes Chauvin's fault. The defense brief goes on to say that prior to trial, the prosecution filed a notice of their intent to seek an aggravated sentencing departure, which is correct. Under Minnesota law, if the prosecution is going for an aggravated sentence, they have to provide advance notice, and the defendant is actually entitled to a separate trial in which they can have a jury decide whether the factors for aggravated sentence have been proven. Derek Chauvin waived the separate trial, probably because his lawyers thought there would be no greater advantage with a jury than with the judge. Waiving the second trial means the judge personally decides whether the aggravated sentencing factors were proven. We will come back to that. Let's quickly go through the defendant's arguments for why the judge should not send Chauvin to prison. Keep in mind, it is the literal job of Chauvin's lawyers to try to get him the lightest possible sentence, so they are going to ask for the lightest possible sentence, whether or not there is any real shot of it, and they are going to do their best to paint Chauvin in a positive light. Like anything that comes out of a lawyer's mouth or pen, just because it was said does not mean it is true. And just because we live in a white supremacist, capitalist Christian patriarchy does not mean that every judge or juror will fall for just any bullshit. Here's my favorite part of the defense brief. It comes right before they start to list the mitigating factors. It says, quote, Mr. Chauvin asks the court to look beyond its findings to his background, his lack of criminal history, his amenability to probation, to the unusual facts of this case, and to his being a product of a broken system, end quote. A systemic argument? What is this cultural Marxist voodoo? For shame, sir. For shame. Is what I imagine Derek Chauvin's alpha male bros would say if they saw that. So then Chauvin's brief goes on to say the defense urges this court to use its discretion to depart downward with respect to disposition and sentence Mr. Chauvin to a stringent probationary term. And here are the factors that they give for why this crime was too mild to follow the sentencing chart. Factor number 1, age. He's too old for prison, you guys. Have mercy. It says, quote, Mr. Chauvin was born in 1976 to a loving mother, father, and sister. Right there, I take offense. Okay, I was born very shortly after this. And I am not too old for prison. Should I have said that? Anyway, loving family, like the Cleavers, blah, blah, blah. Can you imagine if this was like an argument that was believed in general? Anyone in their 40s wouldn't be in jail or prison. Anyone their 40s or older. The defense, on the other hand, says Mr. Chauvin's age weighs in his favor when determining a sentence. The life expectancy of police officers, oh boy, here come the violins, is generally shorter, and police officers have a significantly higher average probability of death from specific diseases than males in the general population. I don't know how true that is. I'm sure that they found some kind of study, but it's ironic, right? Because you know who tends to have a really high rate of premature death? Black people and poor people and black poor people, especially if the police kill them. And then it talks about the damage to Chauvin's life prospects. There's the Brock Turner argument, you know. He's got such a career ahead of him, such a bright future. And then they cite to a case from 1981 that says, yeah, if a defendant is victimized in prison, then both the defendant and society are better off if the defendant is sent to the workhouse. Do they have workhouses in Minnesota in 1981? Or are they might be citing to a case that cites to an older case that cites to an older case. Are the workhouses not in order? So then they say Mr. Chauvin is not the average offender. Prior to this incident, Mr. Chauvin led a hardworking, law-abiding life and has experienced no legal issues until the point of his arrest. Not true. I mean, yeah, he's never been arrested or convicted for anything, but he does have a little bit of a shady record at his job. Again, we'll talk about that in another show. They say that Mr. Chauvin is not the average offender, hardworking, law-abiding, no legal issues, and still has the ability to positively impact his family and his community. I think this is code for he's not poor and black, so please don't give him a harsh sentence. I was taught in law school that when you write briefs, you lead with your best argument. So that was their best argument. He's 45. Factor number 2 for why the court should go easy on Derek Chauvin, according to Derek Chauvin's lawyers. Lack of criminal history speaks for itself. Derek Chauvin has no criminal record, therefore there is no evidence that he is someone who would do crimes as a pattern, therefore he should not get a prison sentence. Problem with this argument is that criminal history is already factored into the sentencing chart. The chart has a spectrum of sentences ranging from 0 criminal history to lots and lots of criminal history, so this is not an argument against following the chart. Enough said. Factor number 3, level of cooperation and attitude in court. The brief says, quote, throughout these proceedings and in the face of unparalleled public scorn and scrutiny, Mr. Chauvin has been very respectful to the judicial process, the court, and the state. After making bail and being released on conditions, Mr. Chauvin remained out of custody, attended all court appearances, was never unruly, was properly dressed for court, and was deferential to the court under all circumstances, etc., etc. End quote. Your Honor, not once during this trial did Derek Chauvin jump bail. Not once during this trial did he ever tell the jury to go fuck themselves. Not once did he do any unhinged Instagram rants like Shane Dawson. Not once did he violate the no shirt, no shoes rule. And also, not once was he black in this courtroom. Therefore, please, please don't send him to prison. What can I say? The lawyers get paid by the hour. Pad the brief, you guys. Pad the brief. The final factor argued by the defense is the support of family and friends. It says, quote, in the eyes of the public, Mr. Chauvin has been reduced to this incident and he has been painted as a dangerous man. Despite serving his community as a police officer for 19 years, receiving consistently high scores on his annual reviews and being well regarded by supervisors, receiving honors, etc., etc. close relationship with his family and friends. And then it says Mr. Chauvin has also received thousands of letters of support since his arrest in 2020 from local and international communities, end quote. Thousands of letters? Now, they didn't say they were nice letters. I learned in school that you should close on your second strongest argument. So the last thing the defense wants the court to know is that Derek Chauvin has a loving family and friends and has received commendations in his job. Side note, it may be true that Chauvin received commendations in his job, but he also has a history of misconduct allegations. Again, we'll talk about it in a future Chauvin chunk. What the defense is trying to say here is that if Chauvin gets probation, he will have a family to help keep him in line, which is a fair point, but not a particularly strong one. What the defense is also trying to say, emphasis on trying, is that Chauvin was a near-perfect individual before this crime. So, I don't know, I guess everyone should get one free murder? That's more or less the claim. Bottom line, is this likely to persuade the court? As Hassan Piker would say, no shot. I will bet any of you a pitcher of beer that there will not be a downward departure from the sentencing guidelines. In other words, Chauvin is going to be sentenced to at least what the chart says. In fact, I am nearly certain that there will be an upward departure and he will get more than what the standard chart says. I believe this because the judge has already ruled that aggravating factors have been met. Remember the thing about how there can be a supplemental trial to determine whether the evidence supports aggravated sentencing? Chauvin waived that and asked instead for the judge to rule on the evidence. The judge did so on May 11th. The prosecution originally presented 5 aggravating factors that they thought should increase the sentence over and above the guidelines. The judge ruled that the evidence presented at trial supported 4 out of 5. Specifically, and let's bring up the document here, it says, quote, the court acting as the trier of fact with regard to sentencing facts finds that the following facts supporting an aggravated durational departure have been proven beyond a reasonable doubt, end quote. And then he, by which I mean Judge Peter Cahill, lists the factors. Number 1, the defendant abused a position of trust and authority. In a nutshell, the judge finds that Derek Chauvin was a police officer, which is a position of trust and authority. Derek Chauvin used excessive force by holding a handcuffed George Floyd in a prone position, which means face down, for anyone who doesn't know that. And he was held down for more than 9 minutes and 40 seconds, which is an inordinate amount of time, and Chauvin knew from his training and experience that this carries a danger of positional asphyxia, and this was particularly egregious, i.e. bad, because George Floyd made it clear he couldn't breathe and he thought he was going to die, i.e. he said those exact words. Plus, the other officers who were there actually said to Chauvin, it looks like he's passed out, you should roll him onto his side, and Chauvin ignored them. And in fact, after George Floyd was unconscious, and after one of the officers checked him for a pulse and couldn't find a pulse, Chauvin still kept Floyd in the same position. He kept his knee on Floyd's neck, and he didn't move him or do any CPR or anything. So this guy is not getting probation, you guys. Aggravating factor number 2 that has been proven according to the judge is that Chauvin treated Floyd with particular cruelty, and the supporting facts are pretty much all of the same facts that were just stated. Aggravating factor number 3 that was found by the court is the crime was committed in front of children, specifically 3 17-year-olds and 1 9-year-old. Obviously, it was a traumatizing experience, and Minnesota law says that this makes a crime worse and deserving of more punishment. Similarly, the law says that if a group of at least 4 people participate in the crime, that also makes it worse. In this case, there were 3 other police officers involved, and they have also been charged, though not yet found guilty. Nonetheless, this fact satisfies the 4th aggravating factor. There is one more factor that the prosecution argued, but the judge rejected. That is that George Floyd was a victim of particular vulnerability. The prosecution gave 3 reasons for why Floyd was particularly vulnerable. Number 1, he was handcuffed The judge says yes, he was, but Floyd was not actually subdued by the handcuffs because he was resisting arrest and refused to get into the squad car, and this was the reason why 4 officers were on him in the first place. So, in other words, even with the handcuffs on, Floyd was still pretty strong. The second arguable vulnerability was that Floyd was intoxicated, and to that the judge simply says that when you look at victims of murder in general, being high on drugs the way Floyd was does not really change much in terms of his vulnerability. I mean, I guess that's a fair enough point, even though one could make a case either way. Lastly, the prosecution argues that George Floyd was particularly vulnerable because he was face down on the ground with 3 police officers on top of him. The judge says that while this is true, it was in fact the cause of death, and the thing that caused the death cannot also qualify as a thing that causes extra vulnerability for purposes of sentencing. You could call that a legal technicality. I think it makes sense because, in essence, the police officers' own bodies were the murder weapon, and a stronger weapon does not change the nature of the person it is used against. A stronger weapon will make a victim more likely to die, but that is only in comparison to other weapons, not to other people or victims, if that makes sense. So, to reiterate, the judges found that the prosecution proved 4 aggravating factors that could warrant a prison sentence longer than the standard guidelines in Minnesota. Again, the guidelines say that for second-degree murder, a person with no criminal history should get anywhere from 128 to 180 months. That's 10 2/3 years at the lowest and 15 years at the highest. The prosecution has argued for twice the highest guideline, i.e. 30 years. If it was legal, I would bet money that the judge is going to go higher than the guidelines, so higher than 15 years. I would bet my own money that it is going to be something like 22 to 30 total. Remember, if the judge wants Chauvin to do serious time, it has to be that much because of the 2/3 rule. A 22-year total sentence means that Chauvin gets released on parole, or supervised release, as they call it, after about 15 years. A 30-year sentence means that Chauvin gets released on supervised release after 20 years. It has got to fall somewhere in between there, I think. When the sentencing happens, if I get proven wrong, then I get proven wrong. But if I am wrong, I don't think I'll be wrong by a lot. Just FYI, we may not find out on the 25th what the sentence is. The 25th is when the sentence hearing is scheduled, but the judge might take time to decide after hearing the arguments. There is still a lot to discuss other than the sentence. For one thing, there remains a possibility that the entire conviction could be thrown out on appeal. Spoiler, not likely, but possible. Also, 1 or 2 of the 3 charges could be thrown out on appeal, and that would mean a revised sentence. There is a lot that could happen, and we have so much to talk about. So tune in for the next Chauvin Chunk, in which we will go over the 3 jury verdicts for each of the counts, the jury instructions, and what issues concerning these are still in play due to Chauvin's post-trial motions. Thank you so much for watching, and I hope at least something of interest has come out of my face. I wore this shirt in hopes that there would be. This is merch from Psychology in Seattle, one of my very favorite YouTube channels. Shout out to Dr. Kirk Honda. He's the coolest. He does therapist reactions to 90 Day Fiancé and other shows. Also does an audio podcast with another therapist named Umberto. Dr. Honda also does songs sometimes because he is a cool Seattle musician, just like Pearl Jam. Shut up, Pearl Jam is cool. Please click the like and subscribe buttons and/or rate Habeas Humor 5 stars on your podcast app. HabeasHumor.com is your one-stop shop for watching, listening, supporting, communicating, and sending your friends. Check it out and follow us on the social media. As always, Do not take any legal advice from this show. It is for entertainment only, and do not make the mistake of thinking that watching or listening to me on this show has formed any attorney-client relationship. The attached notes contain links to the sources used in this episode. Until next time, please get the COVID vaccine if you can. Please, please, please get it if you can. I beg you, and stay legal, my friends.